Hello everyone. We have with us today Neeha Nagpal and Malak Bhatt, who were the advocates for the appellant in the Ansal properties and infrastructure case. They were representing Sushil Ansal. That's right,
Yeah.
Malak and Neha.
Yes.
And we also have with us Sarjana Das, who is a student at Symbiosis, final year student, and she has been tracking a lot of IBC related matters, and she's keenly interested in this topic. So we thought we'll have a very informal kind of discussion on the matter with the two advocates who were representing Mr. Ansal on the matter. It will be really good to have a quick chat with you. So welcome, Neha. Welcome, Malak.
Thank you.
Thank you.
So, even before we start asking, basic questions on the matter, how do you feel about this matter? This has got a lot of media attention because earlier the March judgment of NCLT was somewhat looked at more in the interest of the consumers, wherein a decree holder would have the right to claim as a financial creditor, go under IBC, and now the NCLAT has completely reversed the order. So what is your preliminary take? You were completely involved in the matter, acting for the appellants. So what is your take on this?
So my take is that the NCLT order was actually incorrect on two grounds. One, by then the amendment, first by way of an ordinance and then by way of a notification of the act, had already happened on the 13th of March 2020, which gave a minimum threshold for home buyers if they wanted to initiate CIRP against a corporate debtor.
Sorry to interject. See, we'll get into the technicalities. What was the law? How the law was interpreted in a bit. Just a preliminary comment as to if this is the sentiment in the public that something which was pro-consumer now security holder will not be considered to be a financial creditor. What is your generic view?
I understand that. I of course empathize with home buyers. I empathize with anybody who's out of their money and are waiting their homes. But if you strictly look at it, I think the NCLAT judgment is definitely absolutely correct in law, and it balances the interests of a home buyer and also of a developer, because if every developer is taken into CIRP, we're not going anywhere. So I think it's a balanced judgment for sure.
And I just add one point here. So
Yes.
the NCLAT's judgment is very alive to two very key facts. Number one is that the general trend that we have seen with respect to insolvency resolution processes, especially with real estate projects, has been always on the low. There has not been a single successful resolution plan for a real estate. You see JP, you see Amrapali, everyone's going down the drain. So the NCLAT judgment at one level is very alive to the fact that if I send one more developer to the insolvency process, it may not turn out to be even a successful enterprise for the home buyers. And here we're not talking about only the two home buyers who had filed the petition, but for everyone who has an unsold project under that company's head. Number two, it also kind of gives a erring hat to the home buyers, saying that you cannot have a pick and choose method where you approach the RERA, you take a recovery certificate, and on the basis of that, you also want to get the recovery of that money, and at the same time initiate insolvency process. You can't have everything through a single process. So at some point, it's like I won't say a rap on the knuckle, but it's also an err on the side of caution from the home buyer side also.
Understood. So Neha and Malak, what do you feel that this case at NCLAT level? You think that the arguments and the final judgment, everything was simple enough? There was enough clarity under the laws, or was it more like you had to explain the situation and you had to like derive the interpretation out of them, or was it absolutely clear under the laws?
On an interpretation of the law, it was we had to have an argument. It was a debated, heated argument which went on for on a BC hearing went on, Malak, if I'm not wrong, for about 2 hours, two and a half hours. And we had to nail in the point. We had to rely on other precedent. So that was a laborious exercise undertaken by under the guidance of Mr. Arun Katpalia and our team. And I'm grateful that the NCLAT has marked that fine distinction between a financial debt, a financial creditor, and sort of given a very correct interpretation to Section 5(8) of the IBC.
And just to tick off from your last point, so you were right. The trajectory of this case has not been very easy. And that's largely coming from the empathetic viewpoint held even by courts with respect to home buyers, because at the first hearing to get an immediate stay on the formation of the COC, which is called the Committee of Creditors, to drive home the point that here there is a very clear, and it's a very thin line to draw a distinction between a home buyer who is suing in the capacity as an allottee as compared to a home buyer who is suing in the capacity as a decree holder. So to drive home that point on a day one hearing at the admission stage was obviously a very, very tough task. And then obviously once the NCLAT got into the groove of understanding how the law has developed, and NCLAT has actually developed this law in other cases also. So then to blend it together was really our task.
Yeah.
So will it be not correct to say that the 17th March judgment of NCLT was one of its kind for the first time, wherein they said that a decree holder will be a financial creditor? I thought that was for the first time NCLT gave such a decision.
Yeah. Yes. Somewhere I thought NCLT got swayed. I mean, I don't mean to be erring on any eggshells and walking on eggshells here, but I felt NCLT got slightly swayed. Again, as Malak mentioned, with the whole emotion of a home buyer suffering.
Understood. So, we are all talking about complicated and technical aspects, of the law where you two are the experts. So can I request if one of you can quickly take us through what really happened in the case? Briefly, what were the facts of the case? What were the arguments at the NCLT level? Finally, what was the decision of the NCLT? What happened? You appealed. And NCLAT, of course, the judgment we know. If you can throw some light from day one to, 14th of August, what really happened will be great.
Malak, should I go? Are you going?
Sure, you can. I'll pitch in wherever required.
Okay, so this project is based in Lucknow. It's a Sushant Lok city that's being developed. I think somewhere around 2012-13, it was commissioned by APIL. This father and son bought 2 units there. And then somewhere in 2017, because there were delays, they got the RERA decree. Nothing happened pursuant to that as well. And in mid-2018, they filed this Section 7. That time, it's very relevant. A very relevant aspect is that this amendment to Section 17, the home buyers, which gave a minimum threshold, was not in existence. It came in by way of an ordinance on 28th December and then by way of the Act on 13th of March 2020. The matter was pending before the NCLT, and there were 1 or 2 rounds of settlement that were proposed, but nothing really fructified. At some level, the home buyers were asking for X amount, and there were whatever ABC reason the settlement didn't happen, which finally led to the 17th March 2020 order. Which initiated CIRP, and the moratorium under Section 14 was put in play. On the 13th of March, that the ordinance had turned into the Act, and which was argued briefly, of course, but not factored in. On the 17th, when this order came in, literally overnight, the Corona was at its peak. I mean, not its peak, but things were sort of getting heated up. We knew that NCLAT would be closing at some point because Supreme Court had just come out with their directive on the 16th of March. So we rushed literally overnight. We got the judgment at about 8 o'clock in the evening, if I'm not mistaken.
Yes.
And next morning, we were in court at NCLAT with the appeal ready at 10 a.m. And we managed to get the stay on 20th of March, which basically said that Umang Real Tech, the NCLAT judgment was applied and said that CIRP is limited to these 2 projects in question, where the home buyers were had purchased these 2 units. And secondly, the formation of COC was stayed. Pending, and then the whole lockdown situation happened. Pending in that period of March, April, May, there was a settlement that was arrived at between API appellants and the home buyers. That settlement application was placed on record before the NCLAT with an application under Rule 11, the inherent powers of the NCLAT to withdraw the CIRP proceedings. At that stage, much to our surprise, there were one or two other home buyers for different projects who'd come in seeking to intervene. And secondly, the IRP had filed an application seeking for clarification of the 20th March 2020 order passed by the NCLAT, limiting CIRP to those two projects and staying the formation of COC. Because it is slightly a pick-in situation, because if CIRP is limited to two projects, how do you call for information of only to those projects? Lenders are normally to the company. So there was that whole issue that came up. And the IRP had also mentioned that there were various other since the publication had happened on the 18th of March itself, a lot of claims had already been received for other than these two projects. So that issue was debated, and therefore the bench came to the view that we are not terminating the CIRP proceedings on the basis of the settlement, but they decided to hear the matter on merits, which Mr. Karpalia requested the bench, then please hear us out on merits. We also, of course, argued Rule 11. We also argued that whole line of Pioneer Supreme Court judgment, which says that if the COC is not formed, till such time you can settle the matter. Then the whole argument was on merits, which basically our argument was twofold. First, that decree holders cannot qualify as financial creditors. The interplay between Section 7, Section 5.8, and I'm forgetting one more.
It's fine. It's fine. So Neha, we'll get onto the arguments in a bit. So that's a lot of information to process. So if I can re-articulate that in a very in a simple manner, the two buyers, Mr. Ashok and Mr. Saurabh, they were the buyers correct. They were the respondents at the NCLAT level. So they were the home buyers. They bought certain properties which were under construction. There was a delay in giving the possession and constructing the specific flat. They, went to RERA. They got the order for recovery. They also tried to settle the, matter, but out of court settlement didn't happen. Finally, with the RERA decree, they went to the IBC, NCLT. They invoked IBC and they tried to claim as a financial creditor, and therefore the CIRP process was instituted. That's the case, and NCLT said that yes, they are financial creditors.
Yes.
And therefore the proceedings started, and IRP was appointed, and whatever is the process happened. So this, in short, is the subject matter of the dispute. And then you guys went to NCLAT, wherein you stated that they should not be considered as a financial creditor. Correct. And this is what NCLAT also upheld. That yes, they will not be treated as a financial creditor. Correct. In short, this is the okay. Now the point is that even before you explain and articulate the arguments advanced, also Sarjana and I we were discussing that when you look at this concept of borrower under IBC, it includes allottees, and Ashok and Saurabh are also allottees. Yeah. And so, to what extent, you can try and technically state that, just because they have claimed as a decree holder, they don't have the right. So first, I would like you to just, explain the arguments which were there from your side, the final judgment of NCLAT, and also if you can touch on this. And, Sarjana, please come in with your specific questions if you have any, once they are done with the explanation.
Yes, I'm going to.
Yeah. So,
Malak, I'm going to let you go with this one first.
Okay. See, the argument is slightly technical. I'll lay it out in very layman terms.
Oh, yes, please. Yes, please.
Yeah. So first, let's understand what the definition of financial creditor is. A financial creditor is someone who lends money for the time value of that money. For example, a loan. It's lent to you so that the borrower will earn interest on that time value for giving that money to you. Now, there was at the time when the IBC was new, and there was a discrepancy as to where these home buyers will fit in. because they are not providing any service like an operational creditor to you, which is where a specific amendment was brought in and the definition of financial creditor was changed to specifically include the term allottee. Because as an allottee, as someone who's a home buyer in an unfinished project, what are the two things that I seek? Either I seek possession, I seek completion of the project in time, or I say I don't want to participate in this anymore. I file a claim for refund, which is where money as an allottee comes in, right? Which is where the term used as a financial creditor, which technically does not fit into that larger umbrella of being borrowing for a time value of money, is having specifically included by way of a subsection.
Actually, by way of an amendment when the whole JP issue broke out.
Yeah. So when the argument raised in the NCLT, which the NCLT was not able to appreciate, was the moment you are suing as you're trying to initiate a CIRP as a decree holder, you are seeking enforcement of that decree. Ultimately, what you have in your hand is a adjudication of a debt. You have the adjudication by a court saying that yes, X amount is payable to you. In that case, you are only a creditor. You are not a financial creditor because you have in your hand an adjudication of a debt. At best, you are an operational creditor. Because the moment I challenge that RERA decree before the appellate authority, it becomes a disputed debt. I have disputed that debt. That is something the NCLAT could not appreciate, and it said no matter what, a decree holder yet remains to be an allottee. But if it remains an allottee, then in that case, have they met the threshold? No, they have not, because by that time the threshold was 100 people have to file it together. So this
or 10%.
And what the NCLAT did was, instead of going into the 100, because they said, look, this requirement of threshold of 100 people is already under challenge before the Supreme Court. We don't want to go into it. But they did a very clear, fine distinction between what a creditor is and what a financial creditor is. And that's where it said that the moment you have a decree in your hand, if I'm all throughout, the best part that the NCLAT did was it looked at the petition that these home buyers had filed before the NCLT. And it said, nowhere have you said that you are an allottee. Everywhere you said you're a decree holder. The moment you're a decree holder, then in effect, somewhere, you are trying to seek enforcement of that decree. And the purpose of an IBC is not recovery proceeding. And that's where they said, and that's where that glaring paragraph, which I think is something which says no decree holder will ever be able to file a Section 7, is like a blanket order saying, look, if you have a decree, fine, you can gather 99 other people and file as a allottee.
Or file an order 21.
But don't come here. Don't come here if you are trying to enforce your decree, because that's not the purpose of IBC.
No, absolutely, Malak. So the first question which comes to my mind, and I'm looking at this issue as a completely independent person, and also as a consumer. My personal case, also, I have the RERA order. Personally, I'm also interested in understanding what other avenues I have. So if I look at it more from a consumer perspective, the arguments and the law which you are explaining, does it mean, will it be right to say that the basis on which NCLAT looked at this issue was more of a technical issue, that they didn't file it as an allottee, they filed it as a decree holder? Will it mean that if a similar buyer files it as an allottee with the requisite, whatever is the threshold, 10%, 100 in number, do you think NCLT and NCLAT will revisit this issue, or it's something which is done and dusted?
Oh, tough one at this stage. I'll try. To my sense, at best the NCLT may clarify two things. One is that this is not an absolute bar that the moment you have a decree, you cannot come to court at all, because a genuine allottee may still have an issue with, or may still want to seek possession, but with a different buyer, with a different builder. In which case, the NCLAT may clarify that, look, having a decree is okay, but then sue in your capacity as an allottee, show your bona fide that you genuinely want a resolution plan to go forward. Number two is that a larger clarification may come in to say that within the 100 people, you may not have a decree, but till the extent you are an allottee of a project and you meet the threshold, then even the law cannot stop you from coming here. And that's something which I think with time may come in.
Understood. So why do you think people, or someone will file as a decree holder and not as an allottee? Is there any additional benefit of it? Does it streamline the process? Does it make it more effective and faster?
So from where I see it, I think that when, before the threshold, or even for that matter, after the threshold more so, a decree holder would have thought that I stand at a better position because it's an admitted debt clearly, it's an admitted liability clearly, there's nothing remains to be adjudicated. So there I go in and it's expressed, and if either gives you a twofold thing, either CIRP gets initiated and you somehow in the process get your monies back, or alternatively it becomes a negotiating tool that you sort of, if they're not paying up, and instead of going through the short circuit the whole order 21 CPC process of execution. But now I think this is laid that to rest, that you cannot short circuit the process on the basis of a decree, unless of course there is some clarification to this order later in date. But as things stand today, I don't think that route is available and possible. And coming back to the home buyers, now you can, of course, if you meet the minimum threshold of 100 or 10%, then of course even a decree holder can then go as a home buyer in that realm, as with the others involved.
Understood. So Malak, what do you think? Is this a settled law now, or is there any chance of any appeal on this order, or for that matter, does the law allow for any appeal on NCLAT matter?
Yes.
Will it lie at the Supreme Court?
Yes. In fact, there's a statutory appeal under the IBC itself, where any agreed person, it may not be just the parties before the NCLAT, any agreed person can go and file an appeal. However, we will need to see who wants really to challenge, because it may just be any other home buyer who may want to file an appeal saying that, look, this puts each of us who has actually taken the pains to go to the RERA and get a decree at a pedestal which is much lower than anyone who has not. And that's where we will at least as Ansal's counsel, if we'll have to clarify that that's not the purport of the order. The purport of the order is not to dissuade home buyers from going to IBC, but it is to dissuade people who want to wrongly seek recovery of their RERA certificates or recovery certificates, or any, for that matter, any decree, any court decree also, through the IBC mechanism, because that's time and again been said either by Supreme Court or by NCLAT. And that's where, just coming back to your question,
the intent of the act is resolution.
The benefit is this, that the home buyer saw the definition of creditor to include someone which has been reduced to writing in a decree or not. But that has now at least been clarified to say that may not necessarily give you the benefit of being a financial creditor.
Right.
You may be an OC, you may be another creditor, but not FC.
Right. So if you can just explain it, further on the appeal, where does the appeal lie? Which is the last appeal? What's the limitation period? Within what time we will see that, okay, this is the law. Now, no more appeals, unless and until it's a question of law and someone goes to, the Supreme Court.
So under section 62 of the IBC, any aggrieved person, as Malak mentioned, can file an appeal. I think the limitation period is 45 days from the date of the order. So there could be a variety of people who could really go. In this case, it could have been the COC also, but the COC is not formed. It can be the IRP, but then again, the question is, you have to show how you are aggrieved. So whoever has to go has to meet that threshold of showing how they are aggrieved. It could be another home buyer, but what the NCLAT judgment has done has left that door open, that whoever is aggrieved on any account has their own action in law. So they can either, as the case may be, initiate a Section 7 or a Section 9 against API all over again. Or if they feel that this order will come in their way, if they're a decree holder, then they may also, then that person could be aggrieved and may want to appeal it. And technically,
please go ahead.
Also, there is, I think, a further delay of 15 days or from 45 days can be condoned, but reasons have to be shown for it.
Understood. Also, I see it's a 3-judge bench judgment. Is there some sort of a review which is allowed? Or is this the maximum bench strength?
No, the NCLAT does not have there's no mechanism of reviewing. You can seek modification, but that's only on mathematical or clerical errors. But as such, there is no review procedure before the NCLAT. The only option available to challenge the judgment is now file an appeal before the Supreme Court.
Okay. Understood. Sarjana, please go ahead if you have any specific questions for them.
Yes, sir. Thank you, sir. Ma'am, and so it was very informative because I felt this particular judgment was very unconventional in its way. And I, as a reader, got to know about very different concepts and questions that popped up while I was going through the judgment. So I will ask just a few basic questions, which I feel will answer young lawyers and law students like me to understand the IBC system a little better. Specifically with respect to the matter in concern. So the two main issues that were identified in this matter was obviously the first one being if this matter was fit to invoke Rule 11 of the NCLAT rules for the settlement of the dispute between the parties, and the second being the maintainability of the application filed by the respondents 1 and 2. So keeping that in mind, I would want you to throw some light on the need and circumstances wherein Rule 11 of the NCLAT rules can be invoked.
Yeah. So see, you are right, and this is a very less spoken topic once it comes to judgments like this. If you see the trend which the NCLT and the NCLAT have followed with respect to Rule 11, it's largely been cases where the settlement takes place A, before the COC is formed, and B, where generally no other claims have been received by the IRP. So technically, and this is largely where if you even start from Swiss Ribbons, which is the Supreme Court judgment which lays down the whole discretion given to the courts to withdraw proceedings. It says that it's in your discretion to see that the withdrawal of the insolvency may not have a larger impact. So one can definitely argue that with respect to this case, and that's generally the trend with respect to real estate projects, because the moment a real estate company goes into insolvency, there are hundreds of home buyers claim that go in. So it may not, I may settle in as a company, I may settle in with one person, but does that take away from the fact that A, I have not been able to meet my liabilities with respect to my other home buyers, and generally I've been defaulting or I've been delaying the projects. So as far as the inherent powers are concerned, the order I would say was in line with the trend that the NCLAT was following, which is that if there are other claims received and the claims are substantially with respect to individual home buyers, then justice may not demand that I stop the proceeding right now, because it may be possible that you may not be able to fulfill the project better than someone else.
Right. So thank you. That does explain a lot. So the next thing that I want to ask is with respect to maintainability, of course. So can you give a brief idea about maintainability, but specifically in terms of Ordinance of 2019 and Section 7 application?
So,
like,
I think we've had that discussion in detail earlier also, but we'll just sum it up again for you.
Yes.
Firstly, the three parties here and the respondents in this case did not go as home buyers, they went as decree holders. Be that as it may,
right.
Assuming any other home buyer wants to go against a real estate developer, as on 1st December 2016, when the IBC was brought onto the statute book, this provision under Section 7 did not exist for home buyers. I'm just giving you the legislative history for in relation to home buyers. This came about when the whole furor on the JP matter happened, when JP went into insolvency, and home buyers were left high and dry. That's when the IBC was amended, and home buyers were allowed to come in as financial creditors, and they could also appoint one representative to be on the COC to have their voice represented there. Following that, what started happening was that any one home buyer was empowered to take a big real estate company, a real estate developer company, into CIRP. Which is what became a cause of concern for any real estate developer also. And that led to this amendment being proposed by way of the ordinance on 28th December 2019, which said that you need a minimum threshold. So it was basically a balancing act where either a minimum of 100 or 10% of the home buyers could go and seek initiation of CIRP. What did that do? That sort of, tried to create a consensus between the home buyers. It may not be that every home buyer wants to initiate CIRP, especially given what's happened as mentioned by Malak earlier, in the JP case or the Amrapali, because it's only a further delay. So I think that's where the whole threshold limit came in. And it is, in a way, to my mind, I feel it's a balancing act.
And
Right.
Looking
Understood.
yeah, just to add one thing with respect to maintainability, the reason why the objection on maintainability came around in this case is that specifically there is in the ordinance and the amendment, there is a provision that with respect to ongoing matters which are not admitted, if the requirement of 100 or 10% is not met, then the petition needs to be necessarily amended and the compliance has to be shown.
Within 30 days of
Yes. So if two people are going forward, necessarily that does not meet the requirement. While the ordinance and now interestingly, while the ordinance and the amendment both were under challenge before the Supreme Court in writs, and the Supreme Court had passed a very confusing order to say status quo to be maintained. Now, status quo with respect to an amendment is unheard of as to what it means. So either the petition should not have been admitted at all and kept in limbo till the time the writ is decided, or status quo would mean that you treat the petition as it is, but that was never clarified. Neither does our NCLAT judgment, nor does the NCLT go into it and just brush it aside by saying, so NCLT definitely...
But the only saving grace about the Supreme Court order is that it restricts it to that particular that particular project or those particular set of developers. So, really that confusion doesn't pass on to any other case of a real estate developer.
Right. Understood.
Right. So Malak and Neha, also we are pressed against time. I know, we will not take a lot of time from you guys as well. One last question I have is when you look at RERA and the order which a home buyer gets from RERA is, for all practical purposes, there is no teeth to such an order. There's a long drawn process to, actually execute that order. If you look at how many orders have already actually been executed, how many RERA orders have actually been executed and actually paid, very handful. So from that perspective, how do you see? Do you feel that unless and until there's a consensus amongst the home buyers where the projects are delayed and they, go and file under IBC as a group wherein the threshold is met, is that something, which is a balancing act? Or do you feel that, they having a RERA decree, of course, NCLAT has clarified that they are not financial creditors. But what is your essence? What is your feeling about it? Because see, today, RERA has no teeth. If you look at it for all practical purposes.
No, absolutely. So, with respect to RERA, let me just take this in two parts. With respect to RERA decrees and RERA certificates, generally the trend that at least we've started seeing is with respect, because of the ever increasing interest amount that RERA decrees carry, more often than not now, real estate builders and at least the recently solvent ones have started settling the RERA decrees early because they don't want the exponential interest to become a part of the claim. Because what happens is, it's not the decree itself which may become relevant at the time of the decree being passed. But let's say a year down the line, if the decree is not enforced, but the company actually goes into insolvency at the hands of a bank,
a bank or an NBFC,
then that person's claim even as an operational creditor will include not just the apartment but also the amount claimed under the decree, which will then increase the amount of debt of that company manifold. So these decrees have started actually being settled by the companies. And with respect to the other part, let's say that they are not settled, then what option does the home buyer have is essentially the question.
Right.
Well, yes, you are right that the 100 people criteria is what has to be met, and that's the mandate of law. And what you are telling me is exactly the argument that has been raised at the Supreme Court, is that today, let's assume a situation where I go to the NCLT with 100 people. A builder can very connivingly settle with 7 out of them, bring that number down to 93, and then I'll be left skirting to look for 7 more.
Yeah.
So yes, that larger question still needs to be answered, and that's what we'll have to see as to how this judgment is looked at when the Supreme Court actually decides. Because this judgment will definitely come up when the Supreme Court decides that question of the amendment.
Understood. Understood. No, so thank you very much, Neha and Malak. That was very, very interesting, and thank you for all the informative
for having us.
discussion. So if I have to tell you that in 30 seconds in Anup style, if you have any concluding remarks, what will it be? Apart from celebrating the win, it's a, if you look at it, it's a good judgment if you look at it purely from a legal perspective. Without looking at the emotions and the construct of consumer interest, it's a good judgment. It's in line with what the law actually says. So
Correct.
what's your concluding remark if I have to ask you?
Yeah, go ahead, Neha. You want to take this?
I'll let you go first.
Okay, so three very short points on this. Number one, you're right.
Yeah.
This is, legally speaking, this is absolutely in line with the purpose of IBC and the mandate of the particular provisions. Number two, with respect to home buyers, this creates a balancing act between interest of home buyers and the present practical situation with respect to CIRP, ongoing CIRPs for real estate project. However, number three, it leaves open certain questions as to what will the home buyers now need to do if they are at two places at once, and that probably will stand clarified by the Supreme Court while dealing with the amendment.
Right.
One last point I'd add is that it also teaches us that one can actually get efficacious justice done through video conferencing, and that could also be the way to the future.
That's true.
Thank you. So thank you very much. Thank you for your time. Thank you, Malak. Thank you, Neha. And thank you, Sarjana, for your interesting questions.
Thank you, Abhishek.
Yes, Malak, you were saying something.
I was saying thank you for having us. It was a pleasure.
Okay. Thank you very much. Thank you for your time. Bye-bye.